Well, you all know me probably. I'm Stefano Burki, alias Moses, who's about to hand down the rules of water law through the tables that I brought in my rucksack, which is somewhere over there. But anyway, jokes aside. So this is a session given over the Manifesto on the Freshwater Rule of Law. You have the names of, it's not, nothing mine, personal, nor Jessica's. It's the product of, 5 AIDA members who are also members of the Water and Wetlands Law Specialist Group of the World Commission on Environmental Law of IUCN, plus Jessica, who is also an ELI senior executive, Environmental Law Institute. So we will, illustrate, walk you through why the Manifesto, what it is for, what it is meant for, what purpose is it meant to serve, and then we will actually zoom in on the substance, the contents of the Manifesto. So first we begin with why, we move on to what for, and then we will see what's in the Manifesto for you to know, react, and we will take it from there. So why the Manifesto? Now, assume from real life experience, which is my own personal experience, advising member countries of FAO on the conceptualization and drafting of freshwater legislation, like Marcella has done on many occasions as well. She knows what I'm talking about.
No.
Oh, come on, Marcella. So now assume that you are all, this is a small group of friends, like-minded, knowledgeable about law anyway, most of you, but with an active interest in water anyway. So assume you are all members of the Parliament Committee of Natural Resources. There's a Parliamentary Committee of Natural Resources, which sits every now and then, and has been tasked with the conceptualization of the review and maybe reform of a law on freshwater for your country. So you're members of this parliamentary committee. Some are lawyers, some are not. In fact, that's good because in Parliament sit all sorts of people from different professional backgrounds. And in fact, when you conceptualize and draft a new law on freshwater, you need to have a good mix of lawyers and non-lawyers as well, as we all know. That stands to reason. So you're all members of this committee. Okay, you are tasked with the preparation of a new law of freshwater, or maybe even review first what's on the statute books, and then determine whether there is a need for for reform. But anyway, the idea is to think about a law that governs freshwater resources in your country. So for the development, use, protection, conservation, protection from pollution of freshwater resources in your country. Okay, so my question to you, audience, is, to you members of Parliamentary Committee on Natural Resources, is, where do you turn to for guidance? One, I can tip you off and say, well, the one probably reference that springs to mind is this lady's book on Principles of Water Law and Administration, co-authored with Dr. Carbonella, and in fact, co-authored with Dr. Carbonella. So that's one good source of reference, intellectual, reference that illustrates, the principles and goes into, a lot of detail, and it's very comprehensive. Fine, but if you look at something, okay, that's good, a good food for thought, if you like. But if you want to move, scale up from there and look for, and perhaps a more normative type instrument of guidance, of inspiration. That's a book based on experience. it's an illustration of, essentially drawn from comparative law, basically. But if you want to look at, how to say, something more concise, a more concise normative type instrument or document that could serve you as guidance and inspiration to inform your work of review, assessment, and conceptualization of a new law of freshwater resources. Where's that? Does it exist? Is it somewhere?
Bible.
I mean, the Bible, yes. I'm Moses, I'm supposed to know about it. I cannot say, this is good, Manfred. This is very good, Manfred. Excellent. But the Bible won't go very far, won't help you too much. So the idea, that's where the idea of the manifesto was born, essentially. Perhaps to fill a gap. And in this sense, and I'll now give the floor over to Jessica, but before I do so, Jess, there's something that occurs to me overnight, I must say, overnight. That what we are trying to do through the manifesto is essentially paying a tribute to Dante's work. Dante Caponera is one of the founding fathers of water law, national and international. And the more senior among us, members of AIDA, have had the good fortune of actually meeting Dante Caponera. He's quite personaggio, as we say in Italian. Quite. So essentially the manifesto, in essence, Marcella, picks up from where you and Dante had left off, and tries to scale up, move that type of work and thinking forward in the direction that now we will illustrate. So it's a tribute essentially to the pioneering work of a great man and one of the founding fathers of freshwater law as a separate discipline in its own right. So Jessica, why the manifesto?
Thank you so much, Stefano. And for those of you who don't know me, I'm Jessica Troell. I am a senior attorney and I direct the International Water Program at the Environmental Law Institute. It's amazing to see all of you here today. Basically, picking up on where Stefano left off, what we're sharing with you today, as he said, is the work initially developed by a small group of legal experts, all members of the IUCN World Commission on Environmental Law, Water and Wetlands Specialist Group, that's a mouthful, but also AIDA, the International Association for Water Law, and our own associations, to kind of take this idea that Stefano had and try to give it a body of principles. And it has been shared through pretty extensive consultations so far, but we are really hoping to continue that today with your input, and it is amazing to see so many experts in the room who will have incredibly informed and valuable input for us. The manifesto itself, as Stefano said, really calls attention to and is meant to inspire national level policy lawmakers, but also other stakeholders to start to refocus on the role of domestic legislation as a key pillar of achieving and operationalizing the freshwater rule of law. And I'll get to the definition of that in a moment. Because despite tremendous progress globally in domestic water legislation over the last 50 years, we still all face tremendous challenges to the sustainable and equitable allocation, use, management, and protection of our most vital resource. Some of these challenges that are really the drivers behind the manifesto, the first and foremost being a failure of coherence. That despite the broad international recognition of the need for integrated approaches, many water laws continue to be siloed from environmental and other relevant sectoral laws and planning processes, and this incoherence leads to conflicting policies and undermines effective management. Second, we see globally a profound lack of distributional equity in distributional allocation justice. Too often, legal frameworks fail to align with fundamental human rights, and they don't ensure equitable allocation and increasingly reallocation as we face the challenges of climate change. The voices of many stakeholders, particularly indigenous peoples, local communities, and the women within those communities remain marginalized, and their rights remain unrecognized and unprotected. So some of these principles you can see over on the side are meant to tie into these key drivers that we've noted as having to shape the outcomes that domestic water legislation can achieve for freshwater rule of law. Third, continued environmental degradation. Despite the multifaceted and essential services that we get from freshwater ecosystems, we still are suffering from pollution, over abstraction, and mismanagement that continues to degrade our freshwater life support systems. And finally, there's a fundamental failure to be able to really adapt to climate change, as many water laws continue to lack the flexibility and adaptive mechanisms that we need to build resilience. So why freshwater rule of law? Freshwater rule of law, taking a step back, envisions well-designed domestic water laws that are aligned across the relevant sectors and implemented and enforced by capable governance institutions that are held accountable by an informed and engaged public. That's the vision of freshwater rule of law. This leads to a culture of compliance that embraces environmental and social values, which of course can vary across different countries. But the concept builds on traditional definitions of rule of law and requires that national level water legislation applies universally and equally to everybody, including to the government, that it provides rules that are clear, predictable, and coherent, that it upholds fundamental human rights and ensures due process for all, and establishes legitimate governance mechanisms that foster effective and just implementation and enforcement. And this is really more than a definition. It's kind of a sea change, a big shift in how we conceive of the role of domestic water law and how it's implemented and enforced in the face of the drivers that we just discussed. For example, freshwater rule of law recasts the role of the state as a custodian, not an owner of freshwater resources, which is the case in many countries already, but not universal. The state holds water in trust for the public, for both people and the environment, but also for present and future generations. And this custodial duty is not just a matter of good governance, it's an evolving and justiciable duty. And as climate change risks elevate, for example, so does the custodial burden of the state in this matter. Freshwater rule of law also demands that we recognize and protect all legitimate rights to water through the improved governance of water tenure, which embraces legal pluralism that still exists in many countries around the world and respects the customary and traditional rights of indigenous peoples and local communities, providing a framework for managing the inevitable trade-offs that countries are facing when allocating, and as I said, increasingly reallocating water in an accountable, inclusive, and sustainable way. So the freshwater rule of law is focused on providing a stable, predictable, and just foundation upon which other solutions can be built. So that's the why and the what, and now how is the manifesto. And the manifesto is how we put it into practice. And so what we did last year in Rome was shut ourselves in a room for a week and think to ourselves, what are the principles that need to underlie this? And we tried not to come up with too many because we didn't want to overwhelm everyone, but we also wanted to be comprehensive. And we've come up with a suite of 10 interdependent principles that are meant to serve as guidance for national legal and regulatory reform. I need to say and emphasize really that these are not prescriptive, and they recognize that there are so many national contextual factors that obviously have to inform how the principles are framed, how they're implemented and enforced within a specific country's context. And Stefano is going to talk in just a moment a little bit about how we envision the kind of accompanying tools and evidence and approaches that need to help countries put this into action. But just to put that out there, so you don't think that we're coming down and saying, here's your water law. The principles can be grouped into 4 key areas. First, the principles that address foundational governance issues, and this includes ensuring legal frameworks are integrated across the relevant sectors, not just water, and that institutional roles are clear and accountable. Second, a group focused on rights and accountability, and this is where we talk about water as a public resource and securing water tenure, guaranteeing procedural rights as a core aspect of it. Third, we have a group of principles that focus on effective implementation. Sound governance requires data-driven decision-making, access to justice, and effective compliance and enforcement. And finally, we have principles that recognize the ecological and global dimensions of water, demanding protection for the ecosystem and looking at the relationship between international obligations and domestic obligations. So together we hope, and we want to hear from you whether we've accomplished this, that these principles can provide a clear and actionable roadmap for lawmakers, policymakers, civil society, and others to help to build on existing legal frameworks to secure a sustainable and equitable water future for all. That's a big ask, but yes. So Stefano, I'm going to ask you to come up now.
Now, members of parliament, members of the Parliamentary Committee on Natural Resources, is this of any use to you? I don't think so. Because, I mean, what we've heard so far from Jessica is, I mean, the background, is background. But, you know, what are these people? Where are these principles? I mean, where are they? Okay, let's see. Let's whet your appetite a bit more. And so the mystery thickens. Let's see about what is the purpose of the manifesto. So the idea is, as I said, as I alluded to at the beginning, to provide inspiration and guidance in the reformation and in the reform, the thinking, assessment, or whatever, of freshwater. The idea is not to generate an academic, an academic instrument. This is not an academic exercise. This was born with the intent of making a dent in reality to the extent possible. And to that end, to essentially address the manifesto for the use of countries and through the engagement with countries, inviting a policy review process and a legislative review process about freshwater legislation wherever that is appropriate, of course, because we are not instigating, we are not instigating a revolution, across the whole world. But whenever, there is a need for that, this could be a source of inspiration for countries. So, and how do we intend to, does this group, and maybe, through a larger, AIDA group that may come, on stream as a result of this conversation, and through the WCL, how do we see this, this happening and coming on stream? So, well, we are at the stage now of a consultative process, essentially, where after generating this document, this instrument, we have farmed it out and we try to obtain feedback and comments from interested, members of the qualified public, I should say, through webinars, through events like this, presentations. We had a presentation about the manifesto at the IUCN Congress in Abu Dhabi 2 months ago. So this is an ongoing process, dissemination and debate and discussion about the principles. So then the idea is to generate indicators, criteria for the assessment, the evaluation of freshwater legislation in the statute books, building then distilling good practices that could serve again, inform the application of the manifesto principles, and again help countries in the process of reviewing, assessing, and formulating water legislation. And with that goes capacity building, again engaging with countries to build the capacity to actually use and implement the manifesto, the principles which are in it, in the review, assessment, and formulation of water legislation. So the ambition, in other words, is, like through the work that I did in FAO for so many years, like Dante Caponera did, is the ambition is to engage with countries and to move down, to make sure that the manifesto, the instrument, and the principles in it are brought down to bear in the realities on the ground of countries X, Y, and Z that are interested and ripe for a reconsideration, a review, an assessment, and maybe reform of their water legislation. Now, how to go about that? How to engage countries? That's a big, still issue, which is not quite, we don't have the hooks, the mechanisms yet, but this is something, an ambition that this group has, where the manifesto wants to, aim for eventually. Not to remain sort of up in the air as an academic exercise, but to, as I said, to come down to earth through engagement with countries in the process. Now, in the next slide, and after I hope we've whetted your appetite to know more about the context. Now, what the heck is this manifesto? What's in it?
The drums are playing. The drums started just on time.
So that's it. And the drums have gone off. This now, if you, I have hang on a second. Now, this is. If you want to download the manifesto, you can do it from here, from this QR code. The QR code leads you to the manifesto. If you want to take it up,
Yeah, come up too if it's too far away.
to take a photo of it, feel free to do so. Then there you have the email addresses of myself and Jessica for comments, or whatever, if you want to after this session, if you're interested. We would like also, perhaps I can mention, Gabriel, that this group of Manifesto authors is also constituted also as a task force, as an AIDA task force, is at the same time an AIDA task force. And we intend to open up, to a larger segment, of the AIDA population interested in this exercise. So afterwards, later on, in the aftermath of this conversation, if you're interested, please signal your interest and maybe send us comments, on the manifesto. Which, yes.
To have it by email.
Use microphone.
Just practicality, because if you have to download it by phone and then send it by email, it's easier to have it by email, maybe for IDA members.
Sure, yes.
It'll take you to a link.
It's saying it's deactivated.
Yeah.
It'll take you to the link, right?
Oh, no, it's
Yeah.
deactivated.
It doesn't work. Okay. Well, anyway, we'll surely is available through a link to the IUCN, official IUCN WCL website where the manifesto is posted. Okay, well, we can now shift into, just one. Okay, here, give me just one. These are the tables of the law. Now, can I ask?
Moses has handing down. Moses is
The table. This is the
The
table.
Ten Commandments.
The 10 Commandments. In fact, these are 10. These are 10 commandments. Here, no, Laura. Here, maybe Laura first.
Oh
Laura.
dear. Was that it?
We have a number of these
Oh, dear.
printouts, but anyway.
We're going to have to ask you to share, I think.
Yeah, but we can start with Laura. Or Laura, please. Could you please read out Principle 1, which is there's no numbering, but it's this one.
Okay. Integration and coherence of domestic freshwater related legislation.
Integration, let's say it again.
Integration and coherence of domestic freshwater related legislation. Okay. Should I?
Please go ahead.
Okay. So domestic freshwater related legislation should reflect the complex web of interactions between freshwater, watershed ecosystems, and the multiple uses that sustain life, human health, well-being, and development through sufficient and clear integration. Domestic water-related legislation should also be clear and coherent throughout the spectrum of regulated human actions that impact directly or indirectly on freshwater resources. This includes ensuring that domestic freshwater-related legislation supports effective intra- and intersectoral integration.
Well, what a mouthful, I should say. My goodness me. Huh? Does it make any sense to you? Well, there's a lot packed in there. Huh? So we need to unpack this. This is a pretty complex principle. You have an immediate reaction in that?
How do you do that in practice?
Microphone.
So it's super dense, as you said. Yes, but the question is, in practice, how do you operationalize that?
Okay, very good question. In fact, now, Let us perhaps start from the very end of the principle. The principle says, at the very end, after all this, complex enunciation, in the end it says, including that domestic freshwater related legislation supports effective intra and inter-sectoral integration. Integration, maybe harmonization. Because my mind went off thinking, last night, maybe we are advocating integration, but in fact, when in effect we could also advocate harmonization, which is not exactly the same as integration. But anyway, intra-sectoral. Amy, what, in your opinion, what does intra-water sector? Inside. So you look at the water. Huh? So under the roof of a piece of legislation, a Water Act, under the roof of an umbrella of a Water Resources Act, what kind of water should come? Here, I'm sorry.
Can I just ask a clarifying question?
Yeah, sure.
Because the last part of the sentence opens me up to a question. So the first sections sound like hydrogeology, so natural systems.
Yes.
But then at the end, are you also contemplating other sectors, like energy, like actual, like economic, like use sectors, or is this really supposed to just be natural?
I'll come to that. It's natural.
Okay.
Natural. Okay. So if we look at natural resources, so natural sector. So the intra meaning water, fresh water. So we are looking at what? What kind of water are we looking at? Surface and groundwater. Say that loud.
Surface and the groundwater.
Surface and groundwater is a very foregone conclusion. Well, a big deal. Well, in actual fact, what the manifesto advocates is integration of regulation of surface water and groundwater under one roof. And not, as you had maybe in the past, but as I have seen, surface water being the province of the Water Resources Act, and groundwater being left out, and sort of drifting into mining legislation, for instance.
Yeah.
Well, that's wrong. That's wrong. The manifesto advocates rather integration in that sense. That there should be, under the roof, under the umbrella of one piece of legislation, regulation, protection, conservation, protection of surface water and groundwater as well. Not one and the other belonging. Likewise, if we look at functional integration, not natural resource integration, but functional integration. Have you ever come across laws that, as used to be actually in the past, that would look at pollution control, freshwater pollution control, from a purely, I'm going to say, from a sectoral perspective, through a separate law for pollution control, protection of the environment, separate from a Water Resources Act? I have seen that happening, and to my mind, the manifesto says that you should go the opposite route of bringing under the roof of one Water Resources Act the basic functions of allocation and reallocation of volumes and flows and control of pollution.
Maybe just to give an example, in the United States, we have complete separation with the Water Pollution Act at the federal level, and then the water allocation laws is all at the state level. And there's really no integration there at all.
Also, just because so yappy today. I think that the fundamental split, you're saying that the goals should be aligned because they're related, but at least in the US, the goals are completely different. So, I mean, one of the, I think, problematic things with our water law is the actual water law is all property. It's not about the system, it's about the property allocation. So by definition, It's not just that it's federal and state, it's that that's how it ended up. But it ended up that way because the goals are completely different. So I think the biggest challenge is how do we align the goals, because otherwise the legal frameworks will split.
Absolutely, and I think it's just to say really quickly, I think that one of the other, to add on to that, is that, you know, whether or not you put everything under the umbrella of one single law, that can be a question for each country, but the failures of coherence, and it's not just about pollution, and the different, like you said, the different sort of policy drivers that are behind that. But if you look especially at, you know, I focus obviously on water tenure at the community level or whatever, the drivers for agricultural water management are not the same for provision of basic, basic services. Urban and rural water management are often fragmented. I mean, there's within the sector itself, there are different finance streams, there are different, like you said, different drivers, different policies that are driving allocation that aren't aligned and aren't speaking to each other. So fundamentally, the intra-sectoral gets at this question of, you know, it's coming not just from within the water sector, it's coming from land, it's coming from agriculture, it's coming, and how do we align, as you said, both the drivers and then the regulatory framework that we have for managing allocation, protection, and use of water, so that we're doing it because it's one resource.
Alignment. I like that, this is something that perhaps if you put it down in writing as, what you just said, would be useful, for us. If you want to join the group, in fact, you are already a member of the group. So. Okay.
We're the manifestants.
Right. We're the manifestants for ourselves, yes. So if you want to, please put it down in writing, as something that we would like to pick up from. But because in actual fact, I recognize, that maybe integration is a big word, essentially. So there are many factors that militate against actual formal integration. But so long as one doesn't lose sight that there are interconnections, that surface water, groundwater, allocation and reallocation with pollution control, I mean, they're all sides of the same coin in other ways, and they can't go separate ways, or be regulated separate ways.
I'm assuming the next task for the manifestant would be to create a framework, a methodology, a unified way to ensure integration, because it's great on paper, but how do you do it in practice?
Yes, well, let me give you, okay. Now, if in fact, this is very good, this goes straight to where, what we are alluding to, making the manifesto a live instrument of change, if you like, through that kind of approach. But for instance, to give you and to scale up our conversation about integration, stroke harmonization. So, nuances there. But if we scale it up, the manifesto says, principle 1 says intersectoral in a physical sense, not the, and that comes from what I said and what I alluded to the other day. Okay, this is something that I alluded to on day 1 on Monday in the panel that about groundwater. That not only groundwater, but also surface water. There is so much interaction between what happens on land, not only above groundwater, but also on the side of rivers, and watercourses and lakes, and under the ground in the subsurface space that impacts on freshwater, underground in particular, but also surface water. There's so much of that interaction that occurs in nature that laws fail to capture. Generally, I mean, water laws fail to capture all that complex web of interactions with other elements of the broader natural environment, but also man-made environment, actually, where fresh water occurs, that tend to be lost on water legislation. So the point is, bringing intersectoral integration, I would say maybe harmonization is a better word probably at that level, would be, for instance, ensuring that a land use, town and country planning, legislation looks at and takes into account the impacts of land use decisions, urban development, for instance, decisions on the freshwater system. Like, for instance, the case of a good case in point is the Flemish region of Belgium. There's the land use planning legislation there provides for a water assessment, that must be taken into account in delivering construction and building permits. And the water assessment, what is it, is described and provided for in the Water Act. So there's a link between the Water Act and the spatial, I think it's called spatial planning law, something like that. There's a direct link between the two, not integration, but the link, harmonization. They work the common purpose of protecting freshwater, in particular groundwater, from the impacts of urban development and land use. In France, for instance, you have another good example at the macro level in France, where you have the spatial, again, the land use planning plans, land use planning instruments have to take into account and be in conformity with the water resources planning instruments, both the macro level, the general, and at the operational level as well. So again, you create a linkage there between land and water, between land legislation and land use town and country planning legislation and freshwater legislation. And these are just,
Can I
Just
add real quick, and I'll turn it over to you, and then Slavko also wanted to. But I want to come back to something that you said about the next steps being some sort of coherent process that countries will use to figure out how to do. I don't think that's possible. That's not the goal. The goal is not to come in and say, here's how you do it. The goal is to provide principles and a range of practices that have worked under different circumstances to be able to help countries and indicators for sort of how this might be developed in a specific context. Because you can't have something that's prepackaged that's going to come in and come down and say, here's what you do to certain countries. So that's not our goal. Our goal is to be very, very careful to provide guidance based on evidence, and then a process for countries to analyze their own laws, their own issues around coherence or water tenure or what it is, to be able to see how do we align this better with the principles. So just to clarify that. And then.
I just want to add one suggestion to expand on Stefano's on your land use thing, because this is it's all I think about now is land use, because we have weird ownership stuff, so that's my only tool. But a lot of the land use sort of developments that we're seeing are like you described, where it thinks about how is the built environment going to impact like water quality, for example. But one piece of land use that I'm not seeing yet, and maybe I'm missing it, I would love for someone to tell me, is sort of the other side of that, which is how the built environment is increasing flooding and flood impacts, but also as a potential supply source, if we think about it in advance, in these more climate change times where you have limited but heavy rainfall. What we're seeing are these devastating floods, but we're also not capturing that as a supply opportunity. So I would love to see some of the land use conversations sort of see it from the incoming, but also the outgoing side.
There's examples in Southern
Mike,
Africa.
Yeah, Southern Africa, but what was the giant one that was at Pakistan that just happened? I mean, even Texas, it's
Indonesia.
Yeah, Egypt.
Indonesia.
About this intersectoral integration and cooperation and coordination, such kind of things, each government has something what we could call horizontal coordination. Those coordination is between different departments. We are talking about here about at least 3 or 4 different departments that should collaborate intensively to integrate these issues we are talking about. It is water for sure, agriculture or land use in building industry and everything of that, industry for sure, and so on. There are more of such. So regular or ordinary common principles for horizontal coordination is dependent in each nation what is in constitution, what are in the governmental organization laws and such kind of things. In this term, as I say, this manifesto would be to put more stress on coordination or with the goal of integration of stewardship of water, because water is a fundamental resource for life. It is much more important to coordinate everything. For example, if you have water pollution, protection from pollution, you will have environmental department involved, but for water use it is another, and those are different laws. Permits are in different laws. There are permits in water laws, in the environmental protection for industry and so on. So all of that should be, I would say, advertised in much visible way to say that environmental impact assessment is one very powerful instrument in my experience, but not enough affirmed in national legislation. So if we look into that, we will find much more what could be done if we elaborate duty to make in the process of environmental impact study development, and in the development of the conditions for permits regarding water, different departments, then that could be effective. It could be in the manifest that is appropriate tool in my view for that. But by the way, environmental impact assessment came from United States in 1969.
Yeah.
So, Slavko, I think this you're starting to get into, which is really appreciated, specific tools that were and practices that might be ways of implementing the various principles. And just to call attention to Principle 9, thank you, about coordination across different responsible parties and decision makers. Because that is a key aspect of this too, which you were just raising. I think one of the things we have, Gabriel's next, and then we'll hand it over to you. One of the things that we envision too is collection of these different types of tools that have been used. Because I honestly, that's one of my questions I ask every country I work in is, you know, how do you do interministerial coordination? How do you actually bring stakeholders together? Is it working? And the answer almost always is no. Why? Because the same people don't come to the meetings time after time, because we don't really have the same mandates and we don't care about the same things, because we don't meet, you know, whatever the problem, I'm sure you all have your own litany of reasons why it doesn't work, right? So can we try to distill through this process what is working and what's specifically missing from it, from our perspective, that we can try to strengthen institutionally, and then what needs to go in the statutes to be able to mandate those kinds of things, and what tools are available for implementation and enforcement. So let me turn over to Gabriel.
Yeah, exactly. Exactly.
That's what Jessica has alluded to at this point here. Jessica has alluded to this point.
It's funding, so we all need to raise money to do that.
So, if I may,
yes, please.
I want to maybe push back on something that you all said, and give you a couple of examples. One is, I think one of the things, Jess, you said when you were presenting, that this is not intended to be prescriptive. I actually think it is, and I don't know, you may want to actually embrace it, and I'll give you a couple of examples. I think on one of the slides, and I think in one of the provisions, the idea that water should be a public resource. Come to Texas, right? Or Norway. It's not just Texas. It's Norway, and there's other countries where groundwater, for example, is not a public resource. It's a private resource. So my question then is, well, aren't you being prescriptive when you're saying it should be a public resource? That's one example. Another one is when we talk about integration. Again, U.S. has complete separation of quality and quantity. And you're arguing for integration of this, and so that is prescriptive. The environmental impact assessment, to me, I think that should be mandatory.
Yes.
And I'm not sure you need to avoid being, prescriptive here. And in fact, I think we, as guiding principles, you may want to be.
I think that's a really good point, Gabriel, and I think we have to be more careful in our language, as lawyers always, that the principles are prescriptive. These are the principles that we need to align with. How it happens, the ways in which countries are able to implement the principles, that's where we're not being prescriptive. We're sort of saying, there's not one way of doing, there's not a good or bad way of getting here, but can you get as close to these principles as possible within the context of your national waters? So point incredibly well taken, thank you. And then-
I'll give you the floor right away, Manfred. Because I would say that there are certain things, and actually certain principles, which to my mind are just non-negotiable. So in fact, the ambition is in the end to be prescriptive, I must confess.
At the principle level,
Yes, certain of these principles, like the one that Gabriel alluded to, and we'll delve into that, time permitting, that
Yeah.
particular principle.
And if
So
we're
there-
missing any,
there, in that sense, definitely yes, the answer is yes. Maybe others we can be a bit more flexible. Manfred, please.
Yes, thank you. Regulation, I think, is a means to an end, and not an end in itself. Is that correct? I wanted to continue. I want to say the same thing as Gabriel, more or less. So, I mean, you have. I think you. I'm still developing this idea, so hopefully it comes out clearly to you. I mean, the first thing for a state or for a couple of states or for a region must be that they know what they want to achieve with water management. So there must be an objective, there must be a goal. Principles, either regulatory principles or incentive, financial incentives or whatsoever, should be adapted to that. So there's probably one little thing a bit missing in this manifesto, which I like very much because it is very much in line of what I'm thinking about all these things. I completely agree to. But I have been working in a country, in Tunisia, where actually the situation is a bit that the target to get to, or the objective to get to through water management demands certain principles probably to be reviewed. So if you just add to this manifesto some kind of thing that, I mean, first you need the objective where you want to go in a specific situation, and then try to apply these things, because these principles, they are, prescriptive, as Gabriel said. They are too prescriptive. They are, I mean, you can apply them in Europe. They are very much in line with the new EU resilience strategy, which I've just read this morning, or when I was sitting here. But there are many countries in the world where they would say, Australia, for example, as well, they have privatized their water resources in the Murray-Darling Basin. They would say, water is a public resource? No, sorry. So please try to put in a bit more relativism to the principles, which I like anyway.
Yes,
I just had a foundational governance question on the integration or harmonization. Gabriel gave the example in the United States of where, water quality is governed at a federal level and water rights at 50 different state levels. Is the implicit assumption in this that both should be governed in any sort of overarching act at the federal level? I mean, at the state, the overall level?
No, because it very much depends on the constitutional system.
Okay.
So this is subject to, obviously, adaptation to the constitutional system of a particular country. There you have a federal country, so that discourse probably will never fly because of the division of powers between federal and state governments. But if there is a way, because actually integration, I mean, if you like, can be also be seen as a goal, as a sort of, I would say, long-term goal to be pursued, through maybe creative mechanisms, I don't know, federal policies, that federal funding policies maybe that can invite states to be more responsive, maybe to this vision of bringing together pollution control and water allocation. In Australia, for instance, something similar was experienced, but not at the level of pollution control that I know of, rather allocation, quantitative management, where the federal government provided sort of framework statute with funding, and the states then went along and adopted, harmonized legislation across.
Maybe just to build on this, and I'm thinking, again, in the US context, it might be the concept of subsidiarity that should be integrated into your proposal, that the quantity and quality be implemented together at the appropriate level. So you may still have that federal structure, but even in the US, you have 45 states that have implementation authority for the Clean Water Act. And so maybe that's sort of the, I'm not sure how to quite phrase it.
No, actually, and we had a lot of discussions when we were thinking about what does integration mean, what integration where, how, and the other piece, it's not just intersectoral, it's also multi-level governance, and thinking through multi-level governance across all different types of constitutional structures, federalism, all of that. But I think you're exactly right, and the principle of subsidiarity, I really like that, and sort of embedding that as at whatever level you're talking about. These are the guiding principles. And also within the context of multi-level governance, so that there's coherence, also, and accountability running both ways, up and down. So that was also sort of, now I should say, part of what we're doing is developing an explanatory memorandum, because there's only so much you want to put in a principle. And so, it's difficult to distill and make it punchy and pithy and acceptable for everyone. But we are developing an explanatory memorandum that will elaborate on these kinds of issues and sort of saying, look, in the specific context of federal countries. But that, I actually really think we should, as you said, we should incorporate the subsidiarity principle. Someone else had their hand up.
So I looked at the 10 principles. Fast right now. And in every principle, there is one word that is constantly repeated. There's one word in every principle that is constantly being repeated. And that word is should. So it sounds to me like you are envisioning to make a set of principles, but at the same time, you're all lawyers with the mindset of making a change, so you're trying to push towards a change. So my question, I'm trying to understand here is, if you want to do principles, I think, and I don't know if somebody else agrees, it would be nicer to revise a bit the terminology, to instead of using the word should, to make it more about the principle itself as a principle that can be used by any country later on to get potentially at one point, as you said, you're looking for funding.
So that runs exactly counter to what Gabriel was suggesting, was saying embrace the prescriptiveness of it and let the principles be the thing, that guides this. So, I mean, that's an open discussion. What do you all think?
I mean, again, it depends on what the objective is from the principles. What exactly do you want to achieve?
We want people to follow the principles. They should follow the principles.
Now, you want to say something?
Yeah, I would just say that perhaps we should discern federal state from unitary states, because federal state is much more complicated. If we are speaking about subsidiarity, then we should speak about federal constitution and state constitution, and it is much broader issues. So if we concentrate on states which are not federal or confederal, then it would be more clear with these, and after that to go to more complex constitutional issues.
But the point is anyway that we are well aware that there are differences, and that differences, in the constitutional systems of countries. So,
I don't doubt that you are aware of it.
Huh?
And again, well, okay, now we're on a different slide, but the process for how you engage with countries on this and how this becomes part of an assessment process of legislation has to be taken in these different contexts. And I think that, we're starting here with the principles just to sort of get our feet on the ground with what do we think needs to inform the whole process. Then it becomes what are the good practices and tools for then entering into different circumstances. So absolutely, I think that's going to be a very important question. We have about 5 minutes left.
Really?
I know. Lawyers talked a lot. What? We could go on to another principle to just briefly chat about it, or we could just keep an open discussion going for the next couple of minutes.
If you go more perspective, do they stay as principles?
Principles are supposed to be I'll ask you guys. What are principles?
Well,
Mike.
basically, it's now the discussion when it comes to prescriptiveness about should or could, isn't it? For me, as a principle is something if you put out a vision and you have a set of principles, you have to stand behind them and say that's something we believe should be implemented. It's more the way how you formulate perhaps different options within principles. But once you come up with a set, you really should stand there and say that's our belief, our manifesto. It should be a should in my view. So,
Yes, sure. I mean, obviously, we stand by these. I mean, the group that developed these principles stands by these principles for sure, and believes in these principles.
I mean, I'm not sure what you guys' intentions are for the sort of how long this ends up being. I totally respect, like, keep it pithy. But I do think that what I hear you saying is this idea of outcomes and strategies. So maybe that sidesteps a little bit the prescriptive. Like, to your point, you have to stand behind it, but understanding that in certain legal systems there's a bit of calcification about the existing property right structure. So, but that doesn't mean we're done, right? We wouldn't all be here if we were done. So that's where I think the strategies come in as, like, don't dismiss this by saying, it's too late, we already have this system. Like, this is how we do it. This is the specific land use suggestion, incorporate the built environment into your land or water planning.
And once you get down to that level, it can be kind of a decision tree about saying, like, these are
Exactly.
the ways of doing
And
it.
there's so much room
What
in
are the
that.
considerations that have to inform it?
And there's so much room to do there, and then each individual place can do that respectful. I mean, I do think there needs to be, and back to my initial question, an intersector, the way I'm using sector planning strategy, right? The idea that energy is being planned separately, even before data centers was a non-starter, and now it's going to crush all of us. So, that's a real strategy that we have room to implement, probably everywhere in the world, even if it's differently, that still works within this very calcified structure. So if we think about it as a goal, but then these are real strategies to sort of get away from the dismissal of, there's already these things.
We are actually, maybe one more? Yes,
we do.
please.
Where are these hour-and-a-half sessions? I know.
Thank you very much. Congratulations for this manifesto. It's really wonderful. And I think that it's very important for national governments. And I don't care about if they say that they're federal or not federal, because every country has some national, call it departments or agencies
Counties.
or something, but every country has a national and subnational level. And so I think that it is absolutely important for the national levels. So if they accept this manifesto, this could be very important for the whole structure of the country. Thank you very much.
Thank you.
Okay, thank you.
Any last minute pressing?
Here
Yes.
we have a comment.
Thank you. I have a question about the indicators. I wonder if you use the legal indicators in order to assess the effectiveness of the water laws.
Well, the idea is to develop indicators to measure actually, and in order to be able to assess where the water legislation existing on the statute book stands relative to the principles of the manifesto, to detect gaps, strengths, elements, aspects that need to be changed, etc. And not only that, but we want also, the ambition is also, and I want to perhaps throw it to the group, to bear in mind that the ambition is not to leave the discourse at the level of conceptualization of legislation, but also the implementation of the legislation and the enforcement eventually. So the ambition is also to develop indicators of performance of legislation on the ground.
How do you choose them?
And I friend, why don't you join the group? And you give us your ideas about it.
We're at the very beginning, believe it or not, the very beginning of this process, and that is a really good question. That we start to go down that rabbit hole actually a lot, and then think we need to settle the principles and everybody's opinions on the principles. But exactly so, and that's something that we envision doing in the next steps. Unfortunately, we're at time. Thank you all so much. Definitely want to wrap up.
Simply renewing the invitation to comment,
Yeah.
please. And the things, some of the things that were said, please put them down in writing so that they get recorded,
If you go to the IUCN website, that you can click. I'm sorry, I tried to write it. It's a different keyboard, and it wouldn't. Apparently I can't find the lowercase a. But I know. If you go to the IUCN WCEL website, the manifesto is there. If you have any trouble at all, just email us, and we'll send it to you by email.
Yes, sure. And an invitation, and Jessica, an open invitation to this group.
Oh, absolutely,
to join the
to join
task
us.
force. To join the AIDA task force.
What is the next
If anybody is seriously
step?
interested, please join the task force.
Further development.
Do that, and please join my poster presentation, which is about changing behavior, and one of the levers of changing behavior is regulation. So probably we can think about principles, strategies, goals, whatever. It's just right now in the lower floor of the main building.
So really quickly before we wrap up, just a really important question Marcella asked, what's next? So we are going to have a couple of additional webinars where we invite different audiences. At the World Bank, for example, we have the Water Law Working Group there that's going to have a webinar and hopefully get feedback from a different, a more expanded audience. And then we are also planning on being at AIDA in Oslo. We'll be working there as well. The idea is by around Oslo, we would like to have a final set of principles, because then leading into the UN water meeting, we'd like to be able to kind of have that coming in as a finished document. At the same time, over that period of time, we're going to be creating the explanatory memorandum that's going to go with it as a really important set of guidance and material. So a lot of the questions around sort of how does this get implemented and how are you explaining this, and all of the comments that you are providing and will provide over the next couple of months, I'm sure, in great detail, right? We will include in the explanatory memorandum, as well as obviously taking on board the principles. But please, if you have time and interest, we would really welcome you to join our group of manifestants. And if you do, you get on the WhatsApp group, and the icon for it is actually a picture of Moses with Stefano's face on it. So if that's not consenting, I don't know what it is.
Thank you all for coming.